Yes. Um, the completed answer form to child support. Yeah. Address listed below. Yeah. When you put me in jail. Yes. For the crime that I didn't commit. Oh. See, this is the Division of Child Support to the Clallam County DOC Department of Corrections. Yes. Withhold delivery property and accounts. Yes. Now, I know it sounded funny, $81,615. Yeah. But as far as I know, I still owe that money. Oh, fact, there was the two reference numbers that I didn't get an explanation for. Yes. And then there's the last four digits of my social security number. My birth date. And then it says here, January 5th of 2016 at 8:50 in the morning. Ooch. Now, just looking at it, okay, this petition for the dissolution of marriage, where I talked to you about converting state debt to federal public debt, and then the Department of Revenue yesterday, shush. Now it looks like a large number of corporations are building their business on the refusal to enforce the laws of the United States. Now, I will go through every one of the data providers, yes, where you've shared any of my data that was caused because of somebody that wanted to watch the videos or the emails. Now, let's say I did a GoFundMe account, a medium, that would mean that if I got any donations from any concerned citizen about why it is, yes, that the United States is refusing. See, it was January 5th of 2016 at 8:59 a.m. Yeah. You took $1.56. Yes. Washington State Support Registry. Ooh. Now, yesterday, I was explaining on how to do this. Let's say you had a protection order issued against you. Oh, and the court said, well, she doesn't actually have to sign it. Which of the protection orders does not require the signature of the petitioner? Let's go through all the protection orders and the temporary, yes, the renewal or reissuance of them, yeah, and then the permanent protection orders. I just want to know all the protection orders that this state has issued for the last 25 years, yes, where the petitioner did not have to sign it because they did not have to appear in court. Now, I'm not talking about what law enforcement does. Yes. I'm just talking about the name of the petitioner. Yes. Where you set an actual court date. Yes. Where they did not appear in court. And when the state law, known as the requirements, say, yes, if you do not appear in court, you will not have the protections of the order. Yes. Now, there's this idea. Okay. Let's say I only find 10 of them out of two or 300,000 of them where there's not an actual signature of the petitioner. And it wasn't law enforcement that motioned the court. It wasn't because of an arrest. It was that another judge in a different county decided, well, we don't have to obligate the petitioner to appear in court. There's a possibility that quite a few rights, yes, requirements, and well, it's another $100 billion day. Good for you. Good for you. Now, since I'm going to show you how to do this, yes. Let's say you go on the public website. Yes. Well, I'm not. See, Superior Court Case Summary on case 11200671. Yes. Let's say you look for petition order for protection. Yeah. And you did that for the last 25 years. Oh. And then they issued the ex parte order for protection for 14 days. Yes. And then you have the obligation to attempt service on the actual respondent. It should say served or not served right here. Yes. Then you have another 14-day court hearing, order reissuing temporary order for support. Yes. And for whatever reason, the individual wasn't served. Yes. So then you have another temporary order, and it's a court order pursuant to publication or mailing. Yes. Now, there was this thought, okay, if you can only do it for 14 days for each of these temporary protection orders, yeah, How is it that you had the exemption to the rule in 2015 to have the court hearing 48 days later? Mhm. Now, I would say, just from the court record, yes, that this violated the requirements of the law, to not reissue temporary protection orders 48 days later. Yes. Just because you issued this for 14 days, yes, and this one for 14 days, and this one, and this one, and this one, yes, he does. Now, as much as you as a court right now, I'm telling you right, I'm telling you right now. See, when you take a person's kids, yes, you do. We'll do a little day calculation. Okay. No, I think it's important. Let's say there are other respondents, men and women, that would like to be able to talk to their children. Yes. And the family says, well, we're going to go in there and say the guy's crazy. Pow. And we're not going to have any jurisdiction. Right. We're not going to enforce the requirements of the law. We're not going to enforce the court rules that require notice and opportunity to be heard. Now, well, as I said in the recording last night, there could be a class action lawsuit for every individual that had a protection order issued against them where you didn't enforce the requirements of the law. Yes. You didn't enforce the rules of the court. Yes. And you didn't enforce the rights of the respondent. Pooch. Now, these. No. Well, listen. Oh, excuse me, police department. Pooch. I have I've told you over it.